Due Process, winner of 14 New York and Mid-Atlantic Emmys, including the 2009 awards for Best Interview Program and Best Discussion Series.
You holding me on what you think something I might do. It's nothing concrete. The only thing concrete is that I committed the act before.
He was convicted of rape, served his sentence in full, and yet he's still locked up. Civil commitment for high-risk sex offenders. The conditions, the law. Up next on Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.
A New Jersey child is raped and murdered, and 16 years later, we have a whole new set of laws, Megan's laws. We all know about them, but there's another little-known law that goes much further, that can keep someone locked up for the rest of his life, irrespective of his sentence. I'm Raymond Brown, and on our docket for this edition of Due Process, indefinite civil commitment for those the state calls sexual predators, those thought to pose a significant threat even after their release. We'll hear the arguments for and against, but first, Sandy King is here to tell the story.
Raymond, that crime was so shocking that we all still know the victim's name, Megan Kanka, 7 years old. Her vicious murder at the hands of a child rapist who had struck before, been jailed, and released, made such an impression on this state and this country that there's now a Megan's Law in all 50 states. But some states went further, not just tracking the released sex offender or warning his neighbors, but changing our very concept of crime and punishment, of law and order.
Oh, sweet Lord. Call 911. It happened in there. Most of the customers split. Those we could grab were holding inside.
All right, keep them cozy.
The world of crime and punishment. For generations, we've seen it each night on TV. So it's a world we think we know well.
Hey, Tommy Bell, NYU student.
Get out! Get out!
If the transgressor's caught, there's a trial.
Mr. Foreman, has the jury reached a verdict?
Yes, we have, Your Honor.
Or a plea, and depending on how that goes,
We find the defendant, Ross Morales, guilty.
a place like this, where the convicted is confined for the length of sentence, tempered perhaps by probation or parole, good behavior or bad.
Michael Dobson, you're under arrest.
But what you won't likely see on Law and Order
Don't do the crime if you can't do the time.
is someone like Derek Sessoms,
I walk around with my head up high.
who did the crime, did the time of 15 years, and maxed out in 2002.
They came and got me, didn't tell me anything, and in a matter of hours, they was bringing me in the same very room. They told me that I would only be here for probably 2 weeks.
Now, 8 years later, Sessoms
Holding on to
is
him.
still locked up.
You holding me on what you think something I might do. It's nothing concrete. The only thing concrete is that I committed the act before.
Based on a sexual assault at 16, Derek Sessoms been classified as a sexually violent predator and confined behind barbed wire for as long as the state wants to hold him.
The majority of people who are there at least 5 years, I would think, before they've been getting out. It's rare that we get someone once they're committed out until they've done at least 5 years there.
New Jersey's one of fewer than 20 states that allows civil commitment for some sex offenders post-release. At the urging of the Attorney General, the findings of an assessment team, and the ruling
of one judge.
New Jersey is only one of 3 states that doesn't have jury trials, for example.
And other than the experts, that judge hears no testimony.
So my client has no way at that point to challenge this official record that comes in against him. And we'd really like to have the opportunity to cross-examine live witnesses as opposed to police reports.
Still, those are the rules that since 1999 have sent nearly 2,000 men post-release to this old Hudson jail in Kearney or an annex on the grounds of East Jersey State Prison. And here they remain until and unless the state decides they're not a threat.
I've spoken with many psychologists and doctors and police psychologists, especially about sexual offenses and sexual offenders. And they tell me no matter how long and how much you treat these offenders, there is no cure.
The idea is that just the worst of the worst, the most dangerous sexual predators, are subject to civil commitment.
There's always that possibility that they will go back out into society and commit that offense.
Though some question whether it really works that way.
A lot of us got stuck, and some people made it out with worse records than mine.
His victim was an adult woman, and he was just 16.
You know, there are always exceptions to the rule, and it is unfortunate, but he put himself in that position. He made that decision. Society didn't, and he's paying the consequences for it.
But could it be constitutional to keep someone locked up once they've done their time? The U.S. Supreme Court, in a 5-4 vote, has said yes.
It's a massive deprivation of liberty that turns on an act that someone has committed and has already served a length of prison time for.
There should be no room at all for any individual to ever commit such an act again.
Yet the post-release detention is supposed to be therapeutic, not punitive, treatment, not punishment. But critics say the New Jersey program, one of the most aggressive in the country, may not live up to that standard.
The reason why I still feel like I'm in jail, because I feel as though I've been disenfranchised.
It is a prison. It is utterly not a treatment facility. It's punitive, and most of the time, rather than engage in the kind of treatment that you would expect for someone with a mental illness, they sit around and do nothing.
And some of the patient detainees refuse to take treatment. But most have good reason to conform to what's expected.
Some of them are just older and more mellow. They've come to realize that there's a program that they have to go with, otherwise they're not getting out.
But with more than 400 committed and a shortage of space and staff, the treatment tends to be limited to as little as 3 hours per week.
I have it on Wednesdays in the afternoon after I come from work, and Thursdays in the morning, hour and a half, and basically that's it.
Compared to other institutions of this type, the number of hours of treatment that these individuals get is woefully below any acceptable norm.
And that's the basis for a pending federal suit, one that challenges New Jersey's indefinite detention, not on the grounds that the whole idea is unconstitutional, but that the conditions of the detention, too little treatment in a place too much like jail, are what violate the law.
Virtually every other program is far superior to the one in New Jersey. An expert we retained said the New Jersey program was the worst he'd ever seen.
We should be looking out to protect the victims of crimes or potential victims, not the offenders.
I was 16. I was a juvenile.
Still, Derek Sessoms, a plaintiff in the federal suit, is still insisting
that I should have never came here. I'm still fighting for my freedom to this day.
Our civil commitment of sex criminals considered too dangerous to be allowed on the street has been compared to the detention without trial of suspected terrorists at Guantanamo. And it raises many of the same questions. Does it violate our own basic legal concepts? Are the ones we're detaining really the worst of the worst? And Raymond, does it really make any of us more safe?
Well, Sandy, that's where we'll pick it up here in the studio with just those tough questions. So stay with us.
they have their constitutional rights, and if they've served their sentence, then you have to abide by that.
It's really the severity of their cases, and then it's the Constitution, which says nobody should be held to answer twice for the same charge.
I really don't think they should let them go.
Keep them off the street, because these are sexual predators, and we need to address them with a harsher penalty.
If they felt like if there was going to be a danger to society, then they should have that as embedded in their sentence. But once they've kind of done their time, then it seems like they should be done.
So is civil commitment of the so-called sexually violent predator a violation of basic constitutional rights or a legitimate means of protecting the public? For some answers, we turn to my Seton Hall Law School colleague, Kip Cornwell, who has written extensively about the practice, and to criminal defense attorney Jack Furlong, who's known nationally for his decades of defending the rights of sex offenders. Welcome to both of you.
Thank you, Raymond.
I should disclose to our followers that I have been involved in some cases that pose challenges to this statute, but none that we're going to discuss today. Let me start with you, Jack, because this morning on broadcast television, everybody is talking about a case involving a young woman named Chelsea King who was killed in California. The facts that seem to be emerging, although we all know better than to try someone on TV, are that the principal suspect did 5 years for child molestation and then was permitted to be released. And there are at least one or two other people coming forth and saying, yes, he attacked me too. So if we assume at least the possibility that the conviction follows and there is evidence that this guy was a person who was in the hands of the state, do you think it's inappropriate or wildly fantastic for people to say, we've got to do something, we should be protected from people like that?
I don't think it's wild to say that we should be protected from people of any sort who are dangerous and represent a risk to society. The problem we always get into whenever we start analyzing the sensational case, and every cohort of wrongdoers has one outlier or two outliers or a group of outliers in single digits who tend to drive public policy. So if it turns out this guy has 3 priors, and it turns out that he told his last psychiatrist walking out the prison door, I can't wait to do it again, everybody's going to say, see, that's why California needs a civil commitment law like New Jersey's. Let's put 1,000 people away. It'll make us feel better. But mostly it's security theater.
So your view would be that the bad cases tend to drive policy. Does that mean that we don't need a statute like this, or we need one that's highly restricted to only a very small number of people?
Well, I'm a civil libertarian, so of course I oppose any civil commitment statute that goes beyond the tailored ends of the traditional civil commitment. Is a person dangerous to self, others, and or property, and unable to get treatment on an outpatient basis for that?
I'm going to come back because I want to explore whether we're all satisfied, or any of us are satisfied the state can do that. But Kip, I'm not going to ask you the easy question about whether this is constitutional, because it's constitutional because the Supreme Court said it's constitutional. But let me ask you a deeper question, because we've known each other a long time. Isn't this scheme pretextual? Isn't it pretending? I mean, I've been in these facilities. They look like jails to me. The door is slammed shut, and there is some kind of process that happens before you get there, but a process that's subject to attack. I mean, and these people can't leave as a matter of will. Isn't that really a form of incarceration that's like prison, but with another set of rules, with lower standards, and a much more difficult way to make your way out?
Well, you know, I think that you're right, and to the extent that in this state the environment is not as therapeutic as one would want it to be. But just to be clear, involuntary civil commitment in the traditional sense also precludes an individual's ability to walk out the door. And as Jack said, there's a long tradition of allowing the state to involuntarily detain people who are a danger to others. These are individuals who are a danger to others. In addition to the dangerousness requirement, they have to have some kind of mental illness, and that requirement is also embedded. It's a slightly different requirement.
But let's wander into the minefield of science, because, for example, with respect to civil commitment, there are in some areas, for example, some pretty recognized syndromes which cause people to be violent, and some areas recognize treatment, therapeutic or medicinal, which can alleviate those symptoms. And so that doesn't seem to be quite the Byzantine universe that we have here, where there seems to be a lot of dispute within the scientific community and with both lawyers who look at science and scientists who care about the law about whether we can identify sexually violent predators in some way, and whether they can be treated, and whether, if so, we know how to do it. I mean, those questions seem subject to flux.
Well, we're identifying them by virtue of prior offending. Now, perhaps some of the statutes are over-inclusive in terms of the offenses which qualify. I would allow that. But as to treatment, there's no question that treatment success is limited. On the other hand, there's ample scientific evidence suggesting that it's getting better. And also, I think it's important to point out that
Let me just stop you there at that point. Jack, if you and Kip were in the legislature, I mean, he seems to be a reasonable guy, and he seems to be saying...
He's a handsome young man.
Well, even more than that, he seems to be conceding that maybe we could tighten it, maybe we could make it more rigorous. Is there any way that if you were both in the legislature, you could find common ground, or is your civil liberties perspective one that says, really, either try him and convict him in a long, settled process, or let him go?
Well, compromise is the art of legislation, so my civil libertarian view would be set aside in the effort to reach a compromise. Let me give you a couple facts. One, treatment is, in fact, if properly done, extremely successful at reducing recidivism rates for sex offenders across broad spectrums. And all the literature supports that, and all the professionals who work at Carney will tell you that that's true, which is why they'd like to do more treatment. And Professor Osme, in the tape piece, mentions...
on that piece, 3 hours a week doesn't seem like a lot of therapy.
I was about to say.
I've heard others, and there's litigation that talks about the irregularity and in some cases the inappropriateness. That's obviously litigation which hasn't been resolved yet.
Well, I'm actually part of that litigation, so I should be careful what I say, other than to note that we have an expert's report, not just the one that the professor indicated, that was a mutual expert, a joint expert, state and defense, or plaintiffs and defendants, and that expert said she thought it was the worst facility she'd ever seen, and it was entirely substandard. So, could we craft legislation that made therapy mandatory? Absolutely. Could it be done more cheaply than holding these guys in a maximum security facility at approximately $130,000, $140,000 per year?
Some people would be, I mean, you have a gradation, maybe some people even with ankle bracelets or house arrest or even a probation.
We have that now. We have that now. RCNL, the registration laws say you have to show up at your local police department and they'll tier you 1, 2, or 3. CSL or PSL, community supervision for life, now parole supervision for life. Every convicted sex offender now has a parole officer assigned to him, but he's in the community.
What you're talking about is the criminal justice system as we know it, but with a more complex and refined set of standards for parole, probation, and supervision. Let me just stop. Kip, why isn't it possible for the legislature to say, look, we have really 2 centuries of experience at due process in the criminal justice system. If you want to extend the penalties or extend especially the supervisory capacity, why not do that as opposed to setting up this system which has the aroma of a pretext, even though it may meet a legitimate societal need?
Ray, it's a good question, and to be honest, a state absolutely can do that. The state of Iowa, in fact, is a good example. They decided early on that they weren't going to civilly commit, and what they therefore did is they augmented penalties on the criminal side.
Yeah, right.
So, and that went something like the first was 10, the second was 25, and the third was life. I think civil commitment, if properly done, is far more humane and beneficial for sexual predators, because the simple reality is that the community will not tolerate the release of many of these folks, and the state has, through its police power, the authority civilly to detain them. The Supreme Court has so held. So
let me ask you this question, and I don't want to launch us into a discussion of the death penalty, but I want to just draw this analogy, that the controversy about the death penalty, and one of the reasons we don't have it in New Jersey anymore is that in theory it gets the worst of the worst, but in fact it's extraordinarily difficult to do. This scheme would seem to require, to be viewed as successful, that it gets those who are the most egregious violators, and for those who can be effectively rehabilitated, that happens in a way that is satisfactory scientifically. Is that what's happening in New Jersey? Are you satisfied with that as we sit here now?
No, and let me say that while Jack and many of my colleagues in the Academy have opposed these statutes facially, and I have not, I've always urged that I think that it's important that they be narrowly tailored with respect to offenses and that meaningful treatment be provided. And I don't want to sit here and represent that I think what the state of New Jersey is doing is wonderful. I visited other facilities in other states.
Would you say it's bad, or that it's
in
need of serious change and correction?
I think that...
Careful, I have a subpoena in my pocket. Go ahead.
You'd be an expert for that.
I think that it's important for that the environment be therapeutic. I think that it can be secure in a way that the typical psychiatric hospital's not. And this is very penal.
I know you haven't done a regression analysis, but from what you know anecdotally, what you've read, what you've seen in our package, do you have the sense that really the worst of the worst are there in some kind of way that relates to what we know, or that it's, if not random, not terribly related to the worst offenders being there getting the best treatment?
Well, as even Bahar Azmi would acknowledge, this state has, in fact, ordered the release of a number of individuals whom the state wanted to commit, either initially or when they came up for review. And so I think that suggests that there's some kind of meaningful process, at least the state of New Jersey, that takes place, and other states have had less judicial involvement in that way.
Let me ask Jack if he agrees with you. In fact, I'm not sure that you agreed or disagreed. I think you addressed the question without answering it. But do you think that, assuming this scheme is constitutional and that there really is a rigorous medicinal approach to the problem, that the worst of the worst offenders are really in Kearney?
No, it's a sledgehammer to a thumbtack. There are about 450 guys in Kearney plus the annex.
And how many should be in that facility?
If you were asking me as a betting man, and I am a betting man, I'd bet 8% might actually fit the definition of what someone would call a sexually violent predator, and I think those guys know who they are, and the other guys at Kearney know who they are. They tend to be sociopathic, they tend to have served long prison sentences, and they're predatory towards the other guys at the facility. They beat them up, they take their stuff, they're the bullies in the yard, and there are a handful of them. But most of them, a lot of the ones there are, for example, borderline mentally, you're not allowed to use retarded anymore, but there's another word for it. Sorry. Thank you. I'm sorry for. I
think there are other impairments that don't even belong.
There are guys there with 65, 75 IQs. I once represented a guy who had a corpus callosum that was missing. He couldn't process information from the left to the right of his brain. I've got a guy there right now who reads at about a second grade level. He's never going to improve in therapy because he can't read the booklet, and they're trying to get him, some little booklet training to move him up to third or fourth grade level. That guy does not represent a risk to the community at large. You don't want him to be your babysitter. So it's perfectly okay to say to his minder, whether it's his sister, his mother, whomever, please don't let him go babysitting. And if you do, we're going to take him away from you. But to keep him at an enormous expense indefinitely is just Guantanamo Bay times 100.
I sense that you would at least agree to some fine-tuning or tightening up of the New Jersey system. But the core question is whether this is the best mechanism for satisfying society's need, driven often at times of great public outrage, for some solution to having dangerous people amongst us, especially with respect to children, and a more ordered approach to this problem.
I mean, interestingly, the reason I would tend to say yes to that question is counterintuitive to the intro to this piece, for example, because the idea is that this is terrible for sex offenders. This is a terrible mechanism to use to keep them away from society. I think absolutely the opposite. The alternative to this is going to be long-term incarceration, and there is no question that is constitutional. And there's no question society is not going to tolerate having these individuals released, many of them, released into the community.
It sounds like you're saying it could be worse if you didn't have this as an alternative to more draconian punishment.
This is the best hope for most of those men who commit these offenses. This is their best hope, which isn't to say that it is done perfectly.
I got to ask you yes or no before we go. It was 5-4. Any chance our Supreme Court will revisit this one day and go the other way?
No, they're not going to visit.
This question.
Not the facial validity question.
Right.
No, I don't think so.
Jack, are we stuck with this system because of the political realities and the constitutional regime the court has permitted, and therefore have to make the best of it?
Not if I can help it.
Okay. And is Kip right that essentially this is a guard against something far worse that could happen because of the politically sensitive and the outrageous nature of some of the offenses we're concerned about?
It's in the realm of possibility, 30 years to life instead of 10 years followed by 20 in an institution. That's what he's saying.
What about the more enlightened approach that you believe at least is enlightened, which is more nuanced probation and parole in order to treat these kinds of... Is that likely in the political environment which we live?
Politically, financially, I think it might be likely. It costs us $50-60 million a year to run this institution, and we can do it a lot more cheaply on the street, halfway houses, and parole supervision than we can this way.
Will we see significant change in New Jersey in the next 10 years in how the scheme is run?
Yeah, I think that in New Jersey what we're going to see is augmented treatment and some of the problems that the lawsuit tends to focus on, such as...
So we'll come back and look at all those issues, because that's all we have time for.
Yeah,
My thanks to Jack Furlong and Kip Cornwell. That's it for this edition of Due Process, but we'll be back next week with more on law and justice. One final note, Sandy King this week received the National Unity Award in Media, honoring the best of journalism on minority issues for her mini-doc on prisoner reentry. Thanks for watching. Remember that you can watch us online anytime at njn.net/due process. For Sandy and all of us here, I'm Raymond Brown. Thanks again.
As part of the contingency to the sentence, treatment is necessary. Reentry is more than just, I committed the crime and I served my time. How do I reenter into a society that didn't do well the first time?
They want to keep them past their time, keep them. Give them a little bit more time to think about what they did.
If they said they did a certain amount of the time for the crime that they did, right, then justice was served.
I don't think they should have to stay in state custody, but at the same time, I still feel like they should be on the list.
I'm still doubtful as to whether, in fact, we need to incarcerate people beyond their duly recognized court-mandated time.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.